Wale ambao tulishindana na wao watulize boli, waliharibu nchi yetu, watupatie nafasi tuifanyie ukarabati na tuipange iweze kwenda mbele. Walikuwa na miaka 5 ambayo walitumia kuharibu mambo ya nchi yetu. Uchumi ikaharibika, tukawa na madeni, mambo ya usalama ikaharibika, polisi wakabadilika, wakawa ni watu wa kuwaua Wakenya badala ya kuwalinda. Tumevunja ile ilikuwa inaitwa special sijui nini ya polisi ambayo ilikuwa inaua Wakenya kiholela. That is the history we want to forget. Let our competitors not remind us of the many things they did against this country. We have also a plan on how to secure this country so that we avoid the shame of Kenyans killed through extrajudicial killings and put in Yala River and other rivers. We are going to secure this country going into the future. So I want to promise the people of Kenya that Kenya is on sound footing, and we have a plan that will take this country into the future.
Officers who are brought to court, instead of them being charged, a miscellaneous application was done by the Internal Affairs of the National Police Service Commission, seeking for them. Raise such an application is the DCI or the Functional National Police Service Commission or the DPP. The act that creates, the section that creates the internal unit, section 87, allows it to deal with complaints of police officers who have snatched another police officer's wife. Petty discipline matters, not issues of 2 Indians who are dead. This is a national issue and an international question. It's not about police officers who have been drunk and disorderly, making noise and such things. That is what the internal police unit is supposed to do, to deal with the discipline of police officers within the police lines and outside, the relationship. So we raised that serious question, and the court found out that our arguments are cogent, so we could not proceed with the application for 30 days. We are coming for ruling on that application on the on Wednesday. We put it to the court very expressly that the mandate to deal with this matter is provided for by Kenyans in an entity called IPOA. It is IPOA that needs to investigate this matter. It is IPOA that needs to prosecute these people. But anybody trying to bring an illegal entity, it is a legal entity, the internal unit is an illegal entity, but it is illegal in terms of coming to court. And even contemplating detaining police officers for 30 days, just because the head of state raised this question. As the defense team, we are determined to fight to the Supreme Court to ensure that these 4 police officers and any that they want to arrest is protected. As we clearly put it very clearly, these police officers who are junior are being forced, coerced, intimidated to implicate their bosses, their superiors. Their superiors are not in this matter. Issues about abduction can only be dealt with when we have facts. We have not been given facts, and we have raised that question of law. We hope the court will agree with us, and if the court will not agree with us, we'll move to the High Court to make it very clear that that is not an issue. 2, remember also we are heading to the question, if indeed the state is saying the 2 Indians disappeared while in the hands of the police, then the law, this criminal procedure code section 287 or 387 or 383 provides for an inquest. These police officers should be exposed to an inquest, a public inquest, because the surroundings of the death of these 2 people, of these 3 people, is not clear. So we shall be pushing the way we pushed in the Kianjakoma matter that these 4 police officers are innocent. They are completely being framed up. And you have seen it when I raised it that they are being framed up. You've seen now the entity coming to bring them to court is not an entity known by law. It is an entity's job who is supposed to deal with domestic issues between police officers. The Internal Affairs Unit of the National Police Service, a creature under the National Police Act, Section 87.
Yes. Now, will you take you back to law school?
Yes, yes.
If it is a preliminary objection, then you needed to tell me that you are raising a preliminary objection on points of law and with respect to the purpose, and then whether you are going to go full, through the application fully, so that I know whether you have notified me is also ready. Then we put our house in order. Now, kindly note Prosecution Counsel.
Yes,
This is a preliminary point of law, but on what purpose? What are you objecting to?
We are objecting simply.
Yes.
Internal Affairs Unit of the National Police Service Commission is purporting to appear before you on matters it does not have jurisdiction.
Okay, that will be sufficient.
Yes,
that is
now
noticed.
yes.
Then now you can respond.
Thank you. That the respondents, Your Honor, file a formal PO, Your Honor, to enable us response, or in the alternative, whatever directions that courts will give, Your Honor, before we can proceed with this PO, Your Honor.
Yes, let me. This morning. Can we tell? Section 87, I think get well back with it. If it needs 5-10 minutes, we don't mind. We can come back in 10 minutes, get to our appeal, and let him respond, because it's just. Do you have the dictionary?
I agree with the defense counsel. He does not need to do it in writing. If they are ready and you are ready, it is you who can ask for an adjournment to respond. But that should not, your inability to respond on the spot does not burden from proceeding. Is that okay? Mr.
That's okay, Your Honor. We can proceed with the PO. We will determine, Your Honor, whether.
Although, I need everyone to take a deep breath. I need all of you, and I'm going to take 2 minutes break to have all of you taking a deep breath. It is a court of law, and we all need to be calm, isn't it? We all need to be calm. Now, I also need all the advocates to have somewhere to sit, and I will ask the security detail team to vacate that bench and sit on this side. We will get you more seats so that I can have all the advocates find somewhere to sit. The security personnel, there are 2 chairs here. I also need protection from you, so I need you. Yeah, 2 of you can sit there kindly. There is even another chair here. Now the advocates sit, because I only want Omari on his feet. Thereafter, he'll hand over to the next advocate like that. All right? So I need everyone to take a seat. That is the only way we are going to have a calm audience. Mr. Wangoi, I want you to stop being a bodyguard to Mr. Omari. Thank you very much. Now I am ready to hear you. I'm ready now to proceed.
In the service, 3, keep a record of the facts of any complaint or investigation made. To it, the functions proceed in third, that in the performance of its functions, the unit shall be subject to Article 47 of the Kenyan Constitution. Part 4, the unit shall investigate misconduct and hear complaints A, from members of the service or members of the public. B, the unit shall be at the direction of a senior officer. Or C, on its own initiative. D, on the direction of the Inspector General. E, at the request of the Independent Police Oversight Authority. In sub 6, the unit may recommend the following disciplinary actions to the Commission. 1, the interdiction of an officer. 2, the suspension of an officer. C, the administration of a severe reprimand or a reprimand to control or influence the pay, allowances, or conditions of service of an officer. Lastly, any other lawful action. Your Honor, that is the mandate of the Internal Affairs Unit. Nowhere is it contemplated that it can come to this court to seek orders to interdict, to discipline the 4 respondents. Content of the affidavit, which my seniors, Kahiga and Onge and the others will deal with, are not within that purview. This is the purview, and it is public knowledge, and the court can take judicial notice, and from the content my seniors will deal with, is about the abduction of 2 Indians, which is criminal in nature. It has nothing to do with the administrative action of the 4. Therefore, the bodies known by law to bring such an application is the Director of Public Prosecution, who we have given that mandate. The Inspector General, with his investigative powers, not the administrative wing of the Inspector General's office. Article 245 that creates the National Police Service Commission has not donated complaints of kidnapping, complaints of conspiracy to commit a felony to a small entity called the Internal Unit. You know, the reason as to why the Internal Unit is the one before you it is because this is a political matter where the 4 who come from one ethnic community were interviewed by 4 officers from internal unit from one ethnic community. That is why no policeman wants to swear an affidavit against them. That is why the good office, the Director of Public Prosecution, is running away from his constitutional mandate under Article 157. Your Honor, the court is being misused to settle political scores. These are mere people, junior officers. Let them face the full force of the law within the parameters provided by the law. In the content, they are being said they did an extrajudicial killing. Article 47, which I have put here and read to you, binds the internal police unit that they must act within the Fair Administrative Act and within Article 50 and Article 49 of the Constitution. Do you have jurisdiction to entertain internal affairs unit? You know, you don't have. You don't have. Next time, Your Honor, you will entertain this matter, the HR unit of the police will come before you in a criminal quasi matter to deal with officers. Let a proper application be done by an entity known by law, an entity known by the Constitution, and we avoid this tribal and political witch hunt that is being vested on these 4 officers. You know, that is all. I will allow my other senior, Mr. Onge, to proceed. We are acting together for the first respondent. Then Mr. Kaiga, because of seniority, will deal with that. Then the young associates should deal with the others.
He has also pointed out the jurisdiction of the body that it purports to come before you. I will not belabor the point. The only thing,
just to remind you that when you raise a preliminary objection,
yes,
it's going to be on pure.
Yes, it's on pure points of law.
Yes.
The long and short of it, Your Honor, the long and short of it, Your Honor, is the person purporting to come before you to ask for orders has no locus. And once that individual has no locus, Your Honor, you do not have the hands to deal with it. Decline that invitation at the onset. Don't get mixed up into things that do not belong to this court. That's all.
By my colleagues, in which I adapt their submissions fully, I wish to add that issues of jurisdiction cannot be resumed. They either flow directly from the Constitution or they are statutorily donated. For purposes of exercising the jurisdiction, the party moving the court must be a creature of law, one known by the law, and the law has donated that mandate to exercise those powers. In that particular case, issues of local standard has to be looked at as to the capacity of the party purporting to move the Honorable Court for certain orders, because that puts us squarely at the issue of jurisdiction. In the application dated the 24th of October 2022 and filed before this Honorable Court today. The applicant before you is described as the Internal Affairs Unit of National Police Service. As pointed out by my colleague in details, this is a creature whose powers are not flowing directly from the Constitution or the mother law, that is the statute of the National Police Service. This is an internal department within the National Police Service, and therefore, according to the Constitution and the National Police Service Act, this particular creature has no legal mandate to appear before the court and move the court in the manner it has done. For it to purport to do this application and seek these very critical orders that are infringing on the constitutional rights of the respondents, then that will be abrogating the law, it will be trivializing these proceedings, and it will prejudice the dignity of these honorable courts to uphold the law as it ought to be. As such, our submission is that this honorable court has not been moved in the manner that the law requires, and that puts Your Honor in a position whereby you are not vested with the jurisdiction to interrogate the issues raised in this application. Now that we are dealing with a creature, a non-entity, not known in the criminal procedure or even the Constitution to make the kind of the application they have made. This is an abuse of the court process. It should not be entertained, and we pray that the Honorable Court do exercise its mandate and stamp its judicial authority and strike out this application. That's all.
Before you this morning. Your Honor, it will interest the mind of the court to also note that other than the National Police Service Act, which creates the applicant before court, Your Honor, there is the National Police Service Commission Discipline Regulations of the year 2015, that expand or rather give a detail or details as to the functions of the internal National Service Police Unit, the applicant. Your Honor, I must further note that the authority of the applicant is purely to discipline national police officers as and when they run afoul of what is otherwise defined as offenses against discipline, are set under Chapter 30 of the Service and Standing Orders of the Police. That said, Your Honor, I respectfully submit, Your Honor, that the very design of law is to give officers and officers certain responsibilities. So much so, Your Honor, that however well-intended the applicant might be, it is not in their place to move this honorable court in the fashion they have moved, and at the very least to seek orders that are in essence meant to limit the liberty of the respondents that are before the honorable court. Your Honor, this honorable court has a duty under Article 20 of the Constitution that while interpreting the Constitution, the court must interpret the Bill of Rights and Fundamental Freedoms in a very generous way, respectfully, Your Honor, in a manner that ensures the maximum enjoyment of the rights and fundamental freedoms that are guaranteed to the accused persons, or the respondents for that matter, Your Honor. Your Honor, it's against that premise that I urge the court that as you consider directing my senior counsel for the applicant to go and organize or make his house in order, that at this earliest stage, Your Honor, you will consider giving the appropriate reliefs to secure the liberty of the respondents before court. Your Honor, some of us have been detained by police officers in the recent past, and we know too well they do not find themselves in a very comfortable position. The court is enjoined by the Constitution to protect their right to liberty, order their release on reasonable conditions as we await the fate, if at all, of the application to the 24th day of October 2022, Your Honor. I rest and I thank the court. Thank you.
For the second and fourth. Your Honor, mine will just be very brief to demonstrate the incompetence of the application before you. And Your Honor, this is premised on the affidavit that is sworn in support of the said application. That Your Honor, when you look at paragraph 2 and even on the face of the application, the said application is supported by an investigator from the Internal Affairs Unit. So that to that extent, Your Honor, even the foundational basis upon which the application is being sought falls with it, because the Internal Affairs Unit, as you have been ably led, deals with the internal affairs of the police service. And Your Honor, the nature of the application and the nature of the order they are seeking is not one that is within the purview of an investigator within the Internal Affairs Unit. Your Honor, based on that defect, I will then be adopting the position taken by my seniors that the Internal Affairs Unit is the wrong applicant. It's not the right party seeking the orders before court. And on that basis, Your Honor, the court should not entertain the application pursuant to the limited functions under Section 87 of the National Police Service Act. That's all, Your Honor.
The application before you, that is the application dated 24th of October this year, Your Honor, is properly before you. The applicant, when you look at the application, Your Honor, you'll see that the applicant is Internal Affairs Unit, National Police Service. Now, Your Honor, the questions that you need to ask yourself in determining this preliminary objection, Your Honor, is 2 or 3 questions. One is whether the applicant is a unit within the National Police Service. And the answer, Your Honor, is yes, and I refer you to Section 87 of the National Police Service Act, 87A, which Your Honor, establishes the Internal Affairs Unit. Number 2, Your Honor, the question that you need to ask yourself is the deponent a police officer here? And the answer, Your Honor, is yes. Mr. Michael Kirui, who is before you, Your Honor, just right here, I'll ask him to just show his face to court. Your Honor, is an assistant superintendent of police. He's a police officer, Your Honor. The third question that you need to ask yourself, Your Honor, is whether the 4 respondents, who are they? Are they police officers? Are they civilians? And the question is, they are all police officers. Section 87.2 now says, Your Honor, having answered those 3 questions in the affirmative, 87.2 says that the function of the Internal Affairs Unit shall be to receive and investigate complaints against police officers. Your Honor, so as got to appreciate the context of this application, which Mr. Omari has already highlighted, relates to the disappearance of 2 Indians and 1 Kenyan. And the disappearance, Your Honor, is alleged to have been caused by the respondents, Your Honor, before you. So, when you look at 87.2, is that a complaint, Your Honor? The answer is in the affirmative. Your Honor, there are authorities that have been developed by the superior courts that recognizes Internal Affairs Unit as a unit within the National Police Service and capable of investigating misconduct and criminal activities of police officers. Your Honor, allow me to highlight 2 or 3 of them. One of them, Your Honor, is Elizabeth Gathoni Moremi, and another versus DCIO Nakuru Railways Police Station, and 3 others. Your Honor, this is a 2015 case reported in electronic Kenyan law reports.
And could we have what is defined?
It's an authority, Your Honor. I've given the citation. That's why I'm giving the citation so that they can have have a look.
The young team on the defense team, you are taking savvy, take note.
Yeah.
Because I think he's also using EKLR
Yes,
online,
yes.
yeah.
Yes,
so take
I'm
note of
online.
yes, proceed.
Yes.
That is one.
Elizabeth Gathoni?
Yes, so Your Honor, it is Elizabeth Gathoni Muremi and another versus DCIO Nakuru Railways Police Station and 3 others. 2015 electronic Kenya law reports. Another authority, Your Honor, that again recognizes the Internal Affairs Unit as an investigative agency within the National Police Service is Republic versus Chief Executive Officer, Independent Policing Oversight Authority, and 2 others. Anji Patel, 2019 electronic Kenya law reports. And finally, 2019, sorry, Kenya law reports. Finally, Your Honor, I refer you to Republic versus Authorities, Your Honor, just a highlight that Internal Affairs Unit, Your Honor, is and it has powers to investigate, and indeed it is an investigative agency. It's properly before you, and we pray that you dismiss the preliminary objection and proceed on to hear this matter. In miscellaneous E236 of 2022, 236 of 2022, where court has had an application of this nature and granted the orders, Your Honor. I urge you to dismiss this PO and allow us to proceed with the application, Your Honor. That is all.
What you're being told is that the unit is within the service. The National Police Act creates very many units with specific functions and duties. They still can discipline officers without the court's intervention. We are not challenging that they have their own investigation powers, but limited to discipline, not limited to abduction, not limited to murder. You know, you have been told the deponent, one senior police officer, Michael Kirui, is in court. And among the issues I have raised here, that the officers who investigated these police officers came from the ethnic community of Michael Kirui.
Your Honor, I'll object to this line of questioning. I don't think Your Honor.
Arrest it.
Your Honor, I'll object.
Sustained.
I'll object.
The objection sustained.
Most
Much
of
obliged.
my-
Leave it at that. You withdraw that expansion.
I withdraw that line of thought and put it this way.
Yes.
These officers were never exposed to a fair investigation.
Your Honor, again, I will object to this. Your Honor, the PO is limited on whether or not this application, Your Honor, is properly before you. And in my reply, Your Honor, I did not mention whether they were properly investigated or not. Can Mr. Omari stick to the rejoinder issues and to the rules so that we can save time, Your Honor?
Yes, allow me to guide Mr. Omari as an advocate. He cited section 87, subsection 2, and has given us those two authorities. And he has just made submissions that that unit has investigative powers as per the three authorities he has cited, and that is why I had asked you to sit with your team
They already.
so that you do not get outside. And in that regard, allow me to give you 2 minutes so that you confer. I'm just here so that you can confer and see the best way to respond. The 4 advocates kindly confer. Otherwise, you're introducing new matters.
My lawyers will deal with that angle because they have gotten the authorities, I'm told,
Yes.
they are about employment and dismissal.
Yes.
The
So
lawyers will deal with it.
I will take you back where you had reached, and you were saying that that the agency has its own investigative powers, but it is limited to disciplinary matters, and not matters such as murder
Yes.
and extrajudicial
Killing.
Now you can proceed from there.
And Article 47, which I laid the basis of, expects that unit to discharge their mandate in a fair administrative manner. The 4 are raising that there was no fair administrative action.
Your Honor, allow me. I'm really sorry. Was this part of the PO that was raised? Kindly guide us.
I did raise the question of fair administration.
On fair administration?
I did raise, yes, and I read it.
And in my reply, Your Honor, did I talk about that?
Not in your reply, yes.
Thank you,
All
Your
right.
Honor. Kindly, let's get guidance, please.
All right. Your Honor, the question that has been brought by my good friend is that the 4 respondents are all police officers. Are they entitled to be dealt with under the Kenyan law? Does the rank of police officer exclude them from enjoying the rights of the law and the Constitution? They are still subjects of the Kenyan law. And the Kenyan law says entities that can come to court are not the internal unit. entities that can move the court over their complaint is IPOA, is the DCI, through the DPP. Confirmed that the investigation, the application before you, is about the disappearance of 2 Indians and a Kenyan. That purview of what the applicant wants you to give is not in the purview of Section 87. It is within the police service under different departments. Lastly, you have been told that there was another application in E236 of 2022 that was made before and the court pronounced itself. None of the defense team is aware what the issues and facts were in that miscellaneous application, E236 of 2022. This is a novel application before you with peculiar facts. And we urge the court to make an independent ruling based on the submissions and authorities and arguments the defense has presented before you. Can this court depart from its previous ruling if it is true in E236/222? Yes. Your Honor, we urge this court to deal with this matter. Nothing is out of control. The state could have simply withdrawn this matter, walk outside, remove the internal unit, put the National Police Service Commission or the DPP, and the matter ends. We are simply wasting judicial time over a matter that we are determined to pursue to the Supreme Court. The DPP should simply withdraw this application and file a proper application. We deal with it because that is what is known in law. Now, I leave Mr. Onge 2 issues and Mr. Kahiga 2 issues, then the lawyers will deal with the authorities that they have got. Thank you very much.
And I'd like to just deal with